Now, somebody says that Article 159 of the Constitution of Kenya 2010 provides inter alia for the application of traditional justice systems. So in this video, I want us to discuss how traditional justice systems will operate within the framework of formal law and the Bill of Rights. Now, the Constitution of Kenya 2010 recognizes that justice is not exclusively the preserve of formal courts. Article 159(2)(c) expressly directs courts and tribunals to promote alternative forms of dispute resolution called ADR, including reconciliation, including mediation, including arbitration, and traditional dispute resolution mechanism. Now, this constitutional recognition acknowledges Kenya's plural legal kind of system, where customary norms coexist with formal state law. Now, traditional justice system refers to indigenous, community-based systems of resolving disputes using elders, using clan leaders, using customary practices, using reconciliation, and also using restorative justice. However, Article 159(3) imposes constitutional limits in that traditional justice must not contravene the Bill of Rights, it must not be repugnant to justice and morality, and it should not be inconsistent with the Constitution or with written law. So that TDS are constitutionally recognized but subordinate to constitutional supremacy. So, what is the meaning of traditional justice systems? You see, traditional justice systems are indigenous conflict resolution mechanisms rooted in community customs and values. They involve, elders' councils, they involve clan negotiations, they involve family mediation, they involve restorative compensation, and they also involve reconciliation rituals. Unlike formal courts, traditional justice systems, focus on restoring social harmony rather than punishment. And an example is if two neighbors fight over land boundaries, village elders may mediate and settle the dispute through consensus instead of litigation. And you see, this reflects, African communitarian kind of justice. Now, scholarly analysis recognizes, TGS as enhancing access to justice because they are local, they are cheaper, and they are socially legitimate. Now, let's shift our attention to constitutional foundation of traditional justice systems. Article 159(2)(c) of the Constitution of Kenya 2010 mandates courts to promote traditional dispute resolution. And you see, this elevates, TJS from informal social practice to constitutional recognition. Now, before 2010, traditional systems existed socially. But after 2010, traditional systems, gained constitutional legitimacy. Article 159(3) provides for constitutional limits so that traditional justice is not absolute. It must comply with human dignity, that is Article 28. It has to comply with equality, Article 27. It has also to comply with fair hearing, Article 50, and also children's rights, which is Article 53. So that traditional justice systems must operate within constitutional rights. Now, I want us to look at how traditional justice systems operate within formal law. You see, as on alternative dispute resolution, traditional justice system function as, ADR, that is alternative dispute resolution. And they are useful in family disputes, they are useful in land disputes, they are useful in inheritance disputes, they are useful in marital conflicts, and also in community conflicts. So that courts may actually refer parties to mediation by elders. And an example is, land boundary dispute in rural areas in Kenya. so that instead of lengthy court cases, elders can actually mediate, and these can actually reduce case backlog. If you look at the case of Nancy Nyamira and another versus Drummond Morgan Limited, the facts of this particular case was that there was a land dispute where parties explored alternative settlement. And the issue was whether alternative dispute resolution mechanisms could be encouraged. And the rule is that Article 159 promotes alternative dispute resolution mechanisms. And the application of this particular case was that the court emphasized alternative dispute resolution mechanisms. So the conclusion is that alternative dispute resolution mechanisms are actually encouraged by the courts. Now, the significance of this case is that traditional justice systems can actually complement formal courts. Now, the second way of how traditional justice systems operate within formal law is through the recognition of customary law. You see, traditional justice often applies customary law. The Judicature Act of Kenya recognizes African customary law where applicable, provided it is not repugnant to justice and morality. Hence, customary law plus constitutional compatibility is actually enforceable in Kenya. If you look at the case of Kinyanjui Kimani versus Mwiru Kiganga, the facts of this particular case, involved, a dispute involving Kikuyu customary law. And the issue was whether customary law could apply. And the rule is that customary law is recognized in Kenya if it is not repugnant to justice and morality. And the application is that the court recognized the custom. So the conclusion was that the custom was actually enforced. And the significance of this case is that traditional law remains legally relevant in Kenya. The third way of how traditional justice system operate within formal law is through community-based restorative justice. You see, formal criminal law is punitive, but traditional justice is restorative. So that traditional justice system focuses on apology, it focuses on compensation, and it also focuses on reconciliation. And an example is livestock theft is resolved through compensation and reconciliation. And you see, this actually preserves relationships. Now, let's look at traditional justice systems and the Bill of Rights. You see, the Bill of Rights is the constitutional filter, so that traditional justice system is valid only if rights are respected. Now, the first place for traditional justice system and the Bill of Rights is equality and non-discrimination, and this is found in Article 27. You see, many customary systems historically excluded women, and this cannot continue, especially in this age and time. Traditional forums must treat women equally. If you look at the case of Rono versus Rono, the facts of this particular case was inheritance, favored sons. And the issue was whether daughters could inherit property equally. And the rule is that there is equality under the Constitution. And the application of this particular case was that the court rejected gender discrimination. And the conclusion of this particular case was that equal inheritance was actually upheld. Now, the effect of this particular case on traditional justice system is that custom must respect equality. Now, the second place traditional justice system and the Bill of Rights is on human dignity, that is Article 28, so that any traditional punishment degrading dignity is considered unconstitutional. And examples are, public humiliation, forced rituals, and also degrading penalties. You see, these practices violate dignity. The third place for traditional justice system and the Bill of Rights is fair hearing according to Article 50. You see, traditional processes must observe fairness, they must hear both sides, and the elders must be impartial. And also the participation must be voluntary, and the outcome should not be forced. If you look at the case of Republic versus Mohammed Aldo Mohammed, the court emphasized procedural fairness as central to justice, so that traditional justice must meet fairness standards. The fourth place for traditional justice system and the Bill of Rights is the protection of children. And this is according to Article 53 of the Constitution of Kenya, so that traditional marriage settlements involving minors are considered unconstitutional. Child right must override custom. If you look at the case of AOO and 6 others versus Attorney General, courts protected children against harmful practices. And this case established that traditional systems cannot violate children's rights. Now, let's look at areas where traditional justice systems are actually effective. Now, the first areas where traditional justice systems are effective is land disputes. You see, land is deeply cultural. Community elders understand, historical land relations, and this makes traditional justice systems extremely effective when it comes to matters land. In fact, the Constitution itself, encourages community-based land dispute resolution under Article 61G of the Constitution. The second area where traditional justice systems are effective is in family disputes. You see, family disputes need reconciliation more than punishment. And traditional elders, have consistently helped, to preserve relationships. The third area where traditional justice systems are effective is in succession disputes. You see, traditional systems help interpret family customs. However, constitutional equality applies. Now, let's look at the challenges of traditional justice system. Now, the first challenge of traditional justice system is gender bias. Many systems, still remain patriarchal in nature. And this means women may actually be excluded. And this violates, Article 27 of the Constitution of Kenya 2010. The second challenge of traditional justice system is lack of procedural safeguards. You see, formal courts have clear procedure, and traditional forums may lack evidence rules, they may lack appeals, and they may also lack legal representation. The third challenge of traditional justice system is human rights violation. You see, some customs may violate dignity, they may violate equality, and they may also violate liberty. And such customs are actually considered unconstitutional. The fourth challenge of traditional justice system is enforceability. You see, traditional decisions may lack formal enforcement unless, they are adopted by courts. Now, let's shift our attention to the relationship between traditional justice systems and formal courts in Kenya. You see, traditional justice does not replace courts in Kenya. It actually complements courts. And allow me to demonstrate how, they complement one another. You see, traditional justice is flexible, but formal courts are structured. Traditional justice is community-centered, but formal courts are legal-centered. Traditional justice is restorative, but formal courts are adjudicative. Traditional justice is faster, but formal courts are slower. Traditional justice is cheaper, but formal courts are very costly. So that now courts supervise constitutional compliance. But for formal law in Kenya, it still remains supreme. If you look at the case of Otieno versus Ougo, the facts of this particular case involve burial dispute between a widow and a clan. And the issue was whether Luo custom applied, and the rule is that customary law governs personal matters where applicable. And the application of this particular case was that the court upheld Luo customary law. And the conclusion of this case was that the custom actually prevailed. Now, the significance of this case is that it shows, the coexistence of custom and formal law. Now, let's carry out a critical analysis of traditional justice systems. You see, Article 159 creates legal pluralism, and this reflects, Kenya's social reality. Traditional justice systems in Kenya promote access to justice, they promote social harmony, and they also promote affordable justice. But constitutional supremacy ensures human rights, are actually protected. So that traditional justice system is constitutional only when it is rights compliant. The conclusion is traditional justice system under Article 159 operate as constitutionally recognized under, alternative dispute resolution mechanism. They remain useful in matters of land, in matters of family, in matters of inheritance, and also community disputes because they are accessible, they are culturally legitimate, and they are also restorative. However, their operation is limited by the Constitution and the Bill of Rights, that is Chapter 4 of the Constitution of Kenya 2010, so that they cannot violate equality, they cannot violate dignity, they cannot violate fair hearing, and they cannot violate child protection. So that the Constitution therefore creates, a balanced type of model, so that traditional justice is preserved, but constitutional rights and freedom in Kenya remain supreme. My name is Biketi. If it is your first time here, make sure to follow this channel and to subscribe for more legal lessons.